Good evening, sir.
Good evening to all of you. We'll start in a minute. Yes. Good evening to all of you. To recap, yesterday we had a off because of the cricket match yesterday between South Africa and India. So congratulations to all of you as Indians. We are proud of our team. Now we go ahead. Day before yesterday, we were dealing with specific relief act with special reference to persons dispossessed from property other than by due process of law. And we also said that a summary suit lies under Section 6 and 11, and within 6 months of the wrongful disposition, a suit can be filed complaining against disposition and with a request to be put back into possession. That is what we discussed last time, and we were on what is called rescission of. We were also on rectification that is under Section 26. That's a cheaper remedy which is provided to you, whereby there are wrong entries or mischievous entries made in revenue records or in the document where there's a misdescription of the property or misdescription of the parties. Then straight away the remedy open to you is to go for a rectification deed. But now, according to the circulars issued by the government, both the parties should be present at the time when the rectification deed is executed and registered. But now the scenario has changed whereby both the parties will have to be present at the time when the document is presented for registration, and both the parties will have to sign and admit execution and registration before the registering authority. But when you file a document for rectification, the SRO will request you to produce the parent document also in which the necessary corrections have to be made. And whatever corrections have to be made will also have to be clearly mentioned in the rectification date and then duly signed and duly executed. But here, normally rectification arises in respect of immovable property when the description of the party is wrongly mentioned. Instead of Miss is mentioned as Mrs. and instead of Mr. it is mentioned as something else. Or the schedule of property which is described when there are subdivisions, they are not been properly described. Then in respect of clerical and other errors, it can always be rectified by an instrument executed by the vendor in favor of the vendee. But what is the scenario when the one of the parties don't cooperate, that is the vendor does not cooperate? In that case, a provision has been mentioned, that is what Section 26 is there. It says that you can file a suit for rectification of the instrument under Section 26. Notice goes to the other side, and after hearing both the sides, the court passes an order rectifying the document, and it's also mandatory. Then, when you file such a suit, it is better that you make the SRO also the party so that the necessary entries will be made in the concerned register, kept and maintained by the registrar. And please remember one thing, the court fee which you pay in respect of a rectification suit is very, very minimum. That is Section 43 says the court fee that is paid is only 15 rupees. But it is very, very vague. Suppose it's agricultural land, is it 15 rupees for one survey number or 15 rupees for each survey number? That is absolutely not explained. You don't lose anything by paying 15 rupees in respect of each survey number where the errors and omissions have been committed. So this is what we discussed as far as Section 26 is concerned. This is a procedure whereby the errors knowingly or unknowingly or inadvertently or by oversight have crept in, and in the revenue records where mischievous entries have been made behind your back. And there is absolutely no limitation as far as rectification deed is concerned. If both the parties agree, a simple rectification can be prepared and both the parties can be present at the time of registration. The document will be registered as per law, and the necessary corrections of the parent document will be made by the registrar, citing the registration number through which the rectification deed is made. And rectification deed also, along with the document which you hold, are the documents of your title, and they prove and establish your title over the property concerned, which is mentioned in the schedule. That is what section 26 we discussed. And we also discussed section 27 and 28, which speaks about rescission of contract. That means rescission means it comes from the word resign. And the dictionary meaning of rescission is resign. Resign means avoid, retract, revoke. These are the three or four meanings that is given to the word resign. Or avoidance, you can also say. Here, all contracts vitiated by certain elements are supposed to be voidable. Voidable means which is where the consent is not free, or where there is a breach of the obligations, and where one party does not fulfill his obligations, the contract can be rescinded or the contract can be avoided. But one thing you must bear it in mind: if you want to avoid the contract, you must also be prepared as a vendor to return back whatever money you have received under the voidable contract. You cannot keep the benefit and also avoid the contract. That is, in other words, if you want to exercise the right of rescission, you must also be prepared to give back or restore the benefits received by you. That is the advance and earnest money which has been paid to you and when the contract fails due to some reason. That is what we discussed about rescission. Then we came to a most important topic called cancellation of instruments and decrees, that is laid down in section 31 to 33 of the Specific Relief Act 1963. What do you mean by cancellation of contract? Here also, where the vitiating elements of contract, that is section 15 to 22 of the Contracts Act are prevalent. What are those? Coercion, misrepresentation, fraud, undue influence, and then mistake, unilateral and bilateral. I discussed it, also gave the definition of each one of them, but now we go to the subject in the proper perspective. Sometimes it so happens that a contract is vitiated by coercion, let us say. Under threat, under coercion, under pressure, the document has been executed. And if the document is allowed to remain, it will cause undue what is called hardship to the person who has executed the document. And at the time when the document was executed, the consent was not free. The consent was vitiated. Then, in that case, the contract can be avoided, and the contract is voidable at the option of the party whose consent is not free. Here, one thing you must remember, I told you also that the law of specific relief is based on equity. That means one who comes to equity must come with clean hands, and one who seeks equity must do equity. Then, in that case, Mr. Redmi,
నువ్వు చదువుతున్నావుగా నేనేం చేయను.
so when you want to when you want to proceed for cancellation of an instrument on the ground that the consent is not free and the contract is voidable, then in that case you can always file a suit for cancellation under the provisions of section 31 to 33 of the Specific Relief Act. What are the conditions which apply when you want to file for cancellation? You must first and foremost is you must be a party to the document. You must plead and then establish that the consent was not free and that the contract was voidable at your option, and that you, in case the document is allowed to remain, is going to cause prejudice to you, so you want the document to be cancelled as null and void. Then the second aspect is when the consent is not free, you can get the document cancelled as null and void through the methodology of filing a suit for cancellation. And please bear one thing in mind, that unless you are a party to the document, you can't ask for cancellation. There's a fundamental principle, you must bear it in mind. And when you file a suit for cancellation, both the parties should occupy the same character as far as the contract is concerned. Unless that condition is satisfied, a suit for cancellation is not made tenable. Then I also told you what you exactly mean by instrument. Instrument from different professions or avocations has different meanings. If we take the barber, the instrument that is used in his uh, in his profession is what is called the scissors and a comb, barber's comb as they call it, and the cutthroat razor also, which is used in order to separate your side locks. As far as a washerman is concerned, these instruments are the soap, then the brush, which is used for removing the dirt, and also if you see the rural areas, they bang it against a sort of a stone whereby the dirt vanishes. And again, you use washing. I mean, you use washing powder as well as detergent, and even soap is used for the purpose of washing clothes. All these things are instruments from the point of a washerman. Then, what are the instruments that are used by a person who runs a lathe machine workshop? The instruments which are used in the lathe machine are instruments which are suitable to the trade, and the lathe machine, which is fastened with nuts and bolts, through which they mix different things. Then you take the case of a welder. The welder uses what is called the gas lighter and also the necessary implements which are required for carrying out welding work. Then you try to go to a doctor. I mean, as far as a doctor is concerned or a surgeon is concerned, these instruments are the forceps, the scissors, and other implements which are used in performing an operation. And then, as far as a physician is concerned, what are the instruments he uses? Uses a stethoscope in order to find out whether whether fever exists, and if so, what is the sort of fever, whether pulse rate is correct or the BP is correct. Those instruments which are used to check BP as well as performing an operation or or a stethoscope which is run around the chest of a person in order to find out whether he is ill or not. They are all instruments as far as a physician or a surgeon is concerned. As far as an architect is concerned, the set square which he uses in his day-to-day work, and the instrument, for example, you take the case of a masonry or a mason. For him, the implements are instruments are para, then what I don't know what they call it, but para, then crowbar, and then the tapi which is used for softening, and then the tape which is used for measurement. All these things are instruments as far as people from different professions are concerned. Then, if you go to a cobbler also has got a cobbler has got what is called thread, which is used for stitching your torn cheppals, or the needle, which is used for the purpose of stitching your cheppals wherever it is torn. All these things, those things are supposed to be instruments as far as people of different professions are concerned or avocations are concerned. But as far as a legal man is concerned, the word instrument means anything that is contained in a document, any covenant or any stipulation which is contained in a written document is called an instrument. And the instrument which is used, suppose it is vitiated by any of the vitiating elements of contract as laid down in section 15 to 22, even if one of the elements is not present, then in that case the contract is voidable. Voidable means it can be avoided, it can be rescinded at the option of the party whose consent is not free. But one who comes to equity must also come with equity. That is, if you are the wrongdoer and call the other person the assailant or the person who has violated your right, the courts will not come to your rescue. You will have to mention all the facts and also mention the circumstances under which the instrument as the document has been brought into existence. Then you take the case of a court decree whereby or a suit whereby you are a proper and necessary party, your rights are going to be violated, but deliberately the plaintiff does not make you a party to the suit and takes a decree against some strange person who has no right or nexus as far as the property is concerned. In that case, if a decree is passed without your consent, when your rights are involved, you can always knock at the doors of the court and ask for the documents to be set aside. But please bear one thing in mind, that if you are not a party to a document, If you are not either the vendor or the vendee, you cannot file a suit for cancellation. I'll tell you what you should do. So, in all cases where vitiating elements are present, like that from section 15 to 22, you can always resort to the procedure provided under section 31 to 33. It's an equitable relief. It depends upon the discretion of the court whether to grant it or not to grant it. The conduct of the party, the wrongs committed by a party, the violations committed by a party, the breach committed by a party, and the nature of the document, whether it has been executed under free and fair atmosphere, or the document is vitiated in the sense that the consent of the person is not free, be it a decree or be it an instrument, the under proper circumstance and proper facts and narrated in your plea, the document can be document or the instrument can be set aside, and also the decree which is passed by the court becomes a nullity and it can be challenged. Only condition is you must be a party to the document. Here, this is what section 31 to 33 postulates. Then we go to a situation. Suppose you are not a party to the document. What is the procedure to be adopted? Can you file a suit for cancellation? There is an express bar that unless you are a party to the suit, unless you are badly affected, your consent is not free, or let us say, in that case only, you can go for cancellation. But if you are not a party, you must file a suit for declaration and not for cancellation. I'll give you concrete examples of that, sir. Suppose a husband and wife are there. That is, section 34 and 35 is the only sections which are not executable in a civil court. It is only a decree, a paper decree, which declares your rights, where a right position, cadre, or anything is claimed, status is claimed by one party, where a right, position, cadre, or character is claimed by one person, and the person who to whom it is made denies your status, denies your position, denies your character, denies anything else, then in that case, a suit for declaration would lie, provided you are not a party to the document. Am I making myself clear to you, please? When a right is asserted regarding a position, regarding a character, regarding a pedigree, or regarding a status, then in that case, if you claim that and it is denied by the opposite side, then a suit for declaration would lie under the provisions of section 34 and 35. But what all you have to prove is that you are entitled for a particular status. I'll come one by one. For example, every lady calls herself as the lawfully wedded wife, but no person says I'm the lawfully wedded husband of so and so. So suppose let us say you say that she's not your wife at all and she's someone else. I have no connection with her. I have not seen her. I have no relationship with her, or I have not got married to her, or the marriage, even if she alleges marriage, is not a marriage at all. It is not recognized under any of the provisions of Hindu Marriage Act or any marriage act. Then in that case, please remember you are a free person because you are a male. But as far as the female is concerned, suppose, let us say, even though she may be a lawfully wedded wife, still you deny her status, saying that she is your lawfully wedded wife. Sometimes what happens is, due to no fault of yours or no fault of both the parents, the children are born. What will be the fate of the children, sir? Of course, I should not use the word. They will be called as bastards. That should not be the scenario. Please remember the social trauma which a lady faces in the society when her status is disputed and a person disowns her, though he has married her. Please remember what the society will say. Society will say that she is not the wife and she is a kept mistress, or she is a so and so, so and so. So the question is, there's a social trauma also which is attached to the status of a person. Then in that case, a declaration can be sought that you are the lawfully wedded wife of so and so. Then what are the essentials you have to prove, sir? I think you know the conditions which are necessary for a valid Hindu marriage. Recently, the Supreme Court has initiated saying that only tying of Mangala Sutra or the holy thread is not sufficient. You have to perform Saptapati, that seven steps across the holy fire, both the husband and wife hand in hand, will have to go around the holy fire and take oaths in times of plenty, in times of nothing, in times of sorrow, in times of happiness, in times of difficulties, in times of prosperity. It should not enter your head. Both of you should live as Ardhanarishwara, that is half Shakti and half Shiva. So these are the holy oaths which you take before the holy fire. 7 steps which you take. The Supreme Court has clearly said in the recent judgment last year that performance of Saptapati completes the marriage, and the question is you cannot dispense with performance of Saptapati. But what about the customs which we follow, sir? We follow different kinds of marriages. For example, if you take the Naxalites or the radicals, the question of marriage doesn't exist. What they do is they exchange garlands, and they also exchange rings, and also they are pronounced as husband and wife, or they are living as husband and wife under one roof and under one in one bed. Please remember, you should treat your wife or your female folk with love and respect. After all, she has left some other family and come to your family, and she becomes part of your family. And after using her and after utilizing her services, you disown her. What will be your plight, sir? It is all right nowadays because there is no economic dependence. In Hindi they say, "Tu nahi to aur sahi." Especially after information technology has come, women are more educated, women are more well placed, women get more income than what the men get. So sometimes what happens is inferiority complex creeps in as far as the male is concerned. Right from our Shastras, if you see, male chauvinism takes a dominance. For example, even if we take Ramayana, Ram always dictated to Sita, and Sita always followed his footsteps. But Sita never dictated anything to Ram because Ram was supposed to be the god, and he was supposed to be her better half. But they lived together except for that separation when she was abducted by Ravana. But the question is, there must be mutual trust and confidence in each other, and each one should respect each other's rights. And no one should think that I am superior and the other person is inferior. And when you deny the status, a suit for declaration would lie. But of course, in Hindu law of marriage, you have got a maxim called factum valet. Please remember, India is a country of unity in diversity. We have got different sects, different religions, different customs, different usages, and different forms of marriages. But if you see the marriage of Lord Krishna with Rukmini, it was an elopement marriage. It was not a marriage performed according to the Shastras. That is where Lord Krishna won the war against the brother of Rukmini and abducted her and pronounced her as his wife. Then sometimes what happens is when a person is in war, your biological instincts sometimes give way to your good behavior. You get married to some female, and both of you sahajivanam antaru Telugulo. There, where you live together, produce children. Tomorrow, even assuming it's a 1 day marriage or 2 day marriage or 3 day marriage, marriage is a marriage. And even if all the customs are not followed, law presumes a valid marriage. Sir, how do you prove a valid marriage, sir? Normally, nowadays, of course, you've got different customs, sir, whereby you get a registered marriage also done. When you go to the registrar office, then submit the necessary forms. 1 month waiting period is there, and it will be displayed on the notice board. Anyone having any objections or obstructions should intimate the registrar. And if the 1 month period elapses, the registrar pronounces them as man and woman, and a marriage is validly performed. Then you have got what is called marriages which are performed in the Arya Samaj. In Arya Samaj, necessarily you need not be Hindus, but one can be Hindu and another can be a Christian or a Muslim or whatever it is. But one thing is this: when the marriage is performed in Arya Samaj, you have to what is called assert your allegiance to the Hindu religion. I'll tell you one example, sir. The principle of Arya Samaj and RSS is they say every Hindu should marry a Muslim lady and then get children, and then name the children as Hindu children, and get the child married to another Muslim woman, then get them converted into your Hinduism. Like that, you try to develop or increase your Hindu population. You are forgetting for a moment, sir, if two Hindu children are born, 100 Muslim children are born because there is no limit as far as producing children are concerned. Then in that case, what happens is become a mockery. But here, customs prevail in India because various customs are followed. I could give you one custom, sir, which is followed in Chikarpalli temple. I think if you are in Hyderabad, there's a temple called Chikarpalli Venkateshwara Swami temple. There, among Lingayas, there is a custom called Chira Ravika marriage. What do you mean by Chira Ravika marriage? Both the prospective bride and prospective bridegroom appear before the deity, presiding deity, and the Purohit performs the necessary puja, and then he pronounces them as husband and wife, and then the husband, in consideration of marriage and love and affection for the wife, presents six saris, six petticoats, and six wearing apparel. Then 5 or 10 people are fed in the feast, and then the Arya Samaj issues a certificate called a marriage certificate. Then, of course, amendments are also brought saying that every marriage, either Hindu, Muslim, or whatever it is, has to be duly registered before the registrar, and a marriage certificate has to be obtained in order to get the passport or visa and so on and so forth. So when we have got Gandharva marriage also, where it is what is called elopement. You try, if suppose you find a lady pretty enough, you try to snatch her away from the husband and take her away. So in Muslims also, one important thing is the nikah which is performed. It is a form of a contract whereby there is an offer of marriage, and the two respectable witnesses in the presence of the qazi go to the bride and asks her whether she is willing to take so and so as her husband. And when she says Kabul hai, Kabul hai, then the Qazi says that acceptance has been done, so a marriage has been performed. They also distribute what is called the sugar candy as well as the badam to the people who attend the marriage. Here, one important thing you must remember is that the bride does not see the face of the bridegroom, but the bridegroom does not see the face of the bride. But when there is offer and acceptance on either side, and the consideration also is there, when the meher amount, that is, the husband tries to pay some money in consideration of marriage to the wife, and it is entered in a book called the Siyanama. Siyanama is nothing but the marriage certificate prepared and given by the Qazi, both to the bride and the bridegroom, and the parents of the bride and parents of the uh, bridegroom, and one copy regarding the extract of the Siyanama is given to the parents of the girl and parents of the boy, and the articles which are given at the time of marriage is also recorded, and list is prepared, signed by both the parties, and also the sometimes the contract of marriage is also reduced to writing. But one important thing you must remember, as far as Muslims are concerned, no one is fed on the date of marriage. Next day, a function is hosted called walima, which is normally hosted by the husband in proof of the marriage being consummated. Consummated means, I think I need not explain. Most of you are married people where the nuptials have been performed and the nuptials have been successful, and the bride certifies that the husband is potent enough. The party is thrown up in the next day, where the bridegroom's party hosts what is called the walima party. But slowly, what is happening is even they are almost adopting our customs. But here, what I'm trying to tell you is when the status of a woman is disputed or denied, then she can get her status declared by a competent court of competent jurisdiction. Then the next problem that arises are most of the things arise because of marriage and having multiple wives. Under Hindu law, the second wife is not the legally wedded wife, and the first wife is alive, unless the marriage is broken or divorce decree is granted. But here, the terminal benefits of a person has to be paid at the time of his superannuation. Then what happens is there is what is called a Sautigola between the two wives. That one says I am the legally wedded wife, and the other one says I am the legally wedded wife. Here, both of them are driven to court to declare as to who the legally wedded wife is. That in that contingency, a suit for declaration can be filed to declare as to who is the legally wedded wife and entitled to the benefits. Then also the position comes, I think, job on humanitarian considerations or compassionate grounds. Then in that case, both the rival claimants claim the job, saying that each one is the lawfully wedded wife or so and so. Then in that case, the court has to decide or declare as to who is the legal wedded wife and to whom the retirement benefits are payable. Then the second scenario arises. Suppose a person dies, he leaves certain property. Then in that case, the legal status legal status has to be declared. Then, in that case, most of you advocates know that you can file a suit for declaration that to declare your legal status that you are the sons and daughters or the relatives as far as the deceased or the widow of the deceased. Then you can take a declaration from the competent civil court that you are entitled to the legal status as the sons and daughters or the widow of date so and so. But as far as our state is concerned, it is said when you want your name to be included, mutated in your name in the place of the disease, then you have to file a, there also you file a suit for declaration that you are the legal heir as far as the property is concerned, and also under the judgments of our High Court and to quote Justice L. Narasimha Reddy, who says that half the market value has to be paid towards court fee. I had an occasion of meeting Justice L. Narasimha Reddy during one of the seminars, and I told him, sir, after all, a lady should not lose what she should lose in her life. There's Aro Tanamantara Gada. There, where she loses her husband, and the husband leaves the property, and then from the husband's property, when you want your name to be substituted, then you ask the lady to pay half the market value of the property as court fee. Is it not unjust? Unjust. He says, sir, what to do? I passed the judgment, no doubt. Maybe it may be wrong, but no person has challenged it in the Supreme Court to say the judgment is wrong, but still that judgment stands. Today, a widow or son who wants to be declared as a legal heir, as far as the property is concerned, he must pay court fee at the rate of half the market value, and then alone the suit is maintainable. I'll draw a parallel also, sir. Suppose, let us say, debts are left, fixed deposits, savings bank accounts, so on and so forth. You file an OP or original petition for succession certificate mentioning the debts, and you pay 3% or 4% or 6% as cash court fee. But in a immobile property, no such relief is available. You will have to only proceed under the Indian Succession Act and are the 34 and 35 of the I'm sorry, Specific Relief Act and ask for declaration. But you have to pay half the market value as court fee. Please remember, it's something like గవర్నమెంట్ అంటే తెలుగులో అంటారు చూడండి, పాలోడు అంటారు చూడండి, మీ మీ బంధువులు గవర్నమెంట్ కూడా మీ బంధువు అయిపోతాడు. ఏ విషయంగా బంధువు అవుతాడో అది వేరే విషయం. కానీ ఆ జడ్జ్మెంట్ ఆ తీర్పు వలన ఏమవుతుందంటే, అన్ఫార్చునేట్లీ ది లేడీ ఈజ్ మేడ్ టు షెల్ అవుట్ హాఫ్ ది మార్కెట్ వాల్యూ అండ్ ది గవర్నమెంట్ టేక్స్ దట్ మనీ. Is it not just, but still that judgment still remains? So what I'm trying to tell you is, suppose let us say a suit is filed for perpetual injunction, and injunction is obtained. During the course of the injunction, that is temporary injunction, what happens is the other side continues with this mischief and disobeys the orders of the court. Then in that case, what you have to do as a clever advocate is you must amend or correct or amend and add the relief of declaration saying that so and so on so and so date a order for injunction was passed whereby the other side was restrained from interfering with my possession till the disposal of the suit, but in the meanwhile they have proceeded with the mischief and completed the construction or completed the encroachment or the wrongful act. Please try to declare that wrongful act as unlawful and try to restore the original position. Please remember, as advocates, you must be very, very cautious to see that whenever mischief is committed, even though you obtain an order, you will have to amend your claim and ask for declaration or ask for mandatory injunction also. But here, declaration is whenever a wrongful act has been committed, which is in the process of being committed, or which is being apprehended by you, or it is a fait accompli, you must say that that act is illegal and to declare that act as null and void. Suppose a document is executed wherein you are not a party and your rights are affected, you can always question that document by filing a suit for declaration under the provisions of section 34 and 35. Then again, going further, when does a suit for declaration lie? When a right, position, cadre, or character is claimed by one person, when a position, character, status is claimed by one person and denied by the opposite side, then you can get your status, position, or character determined by a civil court and it is called a declaration. And please bear one thing in mind, the relief of declaration is not executable under the provisions of Order 21. Am I making myself clear to you, please? When you are not a party to a document, when you are not one of the parties, either the vendor or the vendee, then in that case, a suit for declaration would only lie, but not a suit for cancellation. But one thing important you must remember is when you file a suit for declaration, the necessary essential ingredients of section 34 and 35 has to be read and then proved. Then, sir, suppose there is no dispute at all, no one disputes that you are not the owner of the property or you are not entitled for a particular status or for a particular character or for a particular position, and the other side no one is disputing your right, then a suit for declaration is not maintainable. So in your plaint, what you write, you must say, sir, I am so and so, so and so, so and so. I am entitled for a particular status. The opposite side is deliberately denying my title to the property or my position or character, and therefore I have no other alternative than filing this suit. Or you put it the other way around, sir. After the death of my husband, I have applied for mutation of the property and replace the name of my husband and change it to my name. And when I approached the GHMC refused to record my name and mutate the property and directed me to go to a civil court and get necessary things done. Because of this particular scenario, I'm compelled to approach this honorable court and file a suit for declaration that I am entitled for my property being mutated in my name and to be declared as a legal heir as far as the property is concerned. So, first there must be assertion of title, assertion of position, assertion of character, assertion of position, assertion of status, etc. And it should be denied by the opposite side. Unless those ingredients are mentioned, declaration will not apply. And that is the reason it's safer. Most of you, what you do is you file a suit against all concerned. Please don't do that mistake because section 34 and 35 will not apply. What you must say is, second one is GHMC represented by the commissioner, GHMC Tangman Road, Hyderabad, or MRO, whichever mandal it may be, you try to make them a party. And when you are filing a suit against a local body or a revenue authority, please bear it in mind. You have to give the statutory notice under Section 80 of the Civil Procedure Code or Section 685 of the Hyderabad Municipal Corporations Act. Unless you give a notice under Section 80 or 685, your suit is not maintainable. And as far as the HMC is concerned, the municipal corporation is concerned, there's a judgment of Justice B.P. Jeevan Reddy way back in 1971 or 70, whereby he said issuance of notice to the government or the local authority is mandatory as far as Section 685 HMC Act is concerned. And the various courts have also held issuance of a notice under Section 80 whenever you sue the government, the state government or the central government is mandatory and you cannot dispense with that notice. But you have got one provision called Section 80 Clause 2, which says that issuance of notice may be dispensed with for the present. That is, you say the issuance of notice will frustrate the very purpose of the suit, so please dispense with the issuance of notice. Or there is one more clause, 80 Clause 3, which says whenever malafide or wrongful acts are alleged against the officials concerned, no notice is necessary. That's the famous case of T.V. Sharma versus the Hyderabad Municipal Corporation, where the municipality wanted to proceed against T.V. Sharma, who was a prosperous criminal advocate those days, but they said whenever modified is or, or modified acts are alleged, no need of notice under 83. So whenever you file a suit against the municipal corporation or against the state government or the central government, 80 notice is mandatory, but you can file a petition to dispense with the notice under 80 clause 2 CPC or under section 685 HMC Act. This is as far as declaration suits are concerned. Then we go, are you able to follow please? Yes, you can interrupt me also. Then we go to the next relief, the most important relief, which is feeding most of our civil advocates today, is called the law of injunctions. Injunction. What do you mean by injunction? Injunction is defined as a prohibitive relief or it is a preventive relief which restrains the opposite side to commit to stop committing a mischief which is already committed, in the process of being committed, or threatened to be committed, or apprehended to be committed, or where you want the other side to keep quiet and not interfere with your rights of possession of title to the property or your essential rights which you are enjoying from times immemorial, it is called an injunction. Something I told you earlier also when I discussed CPC, it is something like a crocin which you have when you have fever, you have crocin, at least to some extent you get relief. Or suppose you are having headache, you apply Zandu balm, Amrutanjan, etc., to get some relief. So at least for that moment, you feel that something is working because you get a burning sensation when you apply Zandu balm or Amrutanjan. You feel that your headache is going to vanish. So in the same way, to prevent a wrongful act being committed or a wrongful act which is already in the process where it is threatened to be committed or it is apprehended to be committed or which is in the process of being completed, then in that case you can seek the relief of injunctions from a civil court. The provisions which cover injunctions are from section 37 to 39 specific relief act. Then injunction, how many types of injunctions are there, sir? One is interim injunction, ad interim, as I call it, ad interim injunction, AD space interim, INTERIM space injunction, INJUNCTION, ad interim injunction. Second one is temporary injunction. Third one is perpetual injunction. And fourth one is mandatory injunction. Each one I'll discuss it in detail now. Here, when is an injunction issued, sir? Injunction is issued as a protective relief or a preventive relief to prevent a wrong being committed. A wrong which is in the process of being committed, threatened to be committed, apprehended to be committed, or it is in progress. Then you try to stop the other side from committing that wrong. It is called injunction. So, what here injunction is what is called a preventive relief. It is based on three cardinal principles called prima facie case, PRIMA space FACIE means a a case triable on merits based on facts and based on documents. And second condition is balance of convenience. That is the advantage that will cost to you will outweigh the hardship that is caused to the opposite side is called balance of convenience. Then third one is the hardship, the relative hardship, which may be caused in case injunction is not granted. The earliest case decided on injunction was the AR 1963, AP 365, the judgment rendered by Chief Justice Chandra Reddy and Sesha Chalapati of the composite Andhra Pradesh state. They said all the three conditions will have to be satisfied for grant of injunction. Perhaps it was passed when your CPC was not amended. Then he said three conditions have to be satisfied for grant of injunction. And he also said It is based on two equitable principles. That is one who comes to equity must come with clean hands. There shall not be any suppression. There shall not be any concealment. It should be in a transparent manner. All facts and documents which are necessary for disposal have to be filed and asserted. And the second one is one who seeks equity must do equity. That means you must not be the wrongdoer. You must be the victim, and the other person should be the assailant who attacks your rights. Then only if these two conditions are satisfied, the equitable principles apply. And please, please, please bear one thing in mind that unless these equitable principles are followed, courts will not come to the rescue. That's why they say you shall not take the other side by surprise, and all facts and all documents which are necessary for disposal of a case, which supports your case, you must first and foremost establish that you have got a triable case based on facts and based on documents, and also show that the law leans more towards you on facts and law, and then in case the order is not granted, you will suffer irreparable loss. And then only an injunction can be granted. We'll go one by one, please. What do you mean by add interim injunction? Add interim injunction is whenever, as an advocate, you approach the court and file a suit for injunction, the court grants, suppose, let us say, you are able to prove and establish a prima facie case or all the conditions are satisfied, the court can grant add interim injunction. Add interim injunction is injunction only for a specific period of time. It's not permanent in nature, sir. And because this was the scenario before 1976, in 1976, the CPC was, in 1976, they say ex parte injunction shall not be granted unless reasons are recorded and cogent reasons are given. As a matter of right, ex parte injunction shall not be granted. So, as far as ad interim injunction is concerned, it is given for a limited duration of time and it is extended from time to time unless the other person is heard and the other person files his documents and asserts his fact in defense. And then once he files the documents, then the matter is heard threadbare, and then the court adjudicates the matter. And if you make out the three ingredients as stipulated in section 37 to 39, the court grants you temporary injunction. And temporary injunctions are normally issued under the Civil Procedure Code from in Order 39, Rule 1 and 2. But it is not issued under the specific relief act, but the position is all the principles laid down in specific relief act applies as far as temporary injunction is concerned. It continues till the disposal of the suit. Then, once the court agrees with you, after arguments on facts and documents and three conditions are satisfied, the interim injunction gets converted into a temporary injunction and it subsists till the disposal of the suit. Then after that, evidences are laid on both sides that the plaintiff has, that is as far as the plaintiff and defendant are concerned. And then in that case, what happens is the court, based on facts and documents and the evidence that is on record and the case law on the subject, converts a temporary injunction into a perpetual injunction. That means forever. And please remember here, as far as perpetual injunction, please know, you should know the stages in which the injunctions are granted. Interim injunction is granted at the time of filing as a temporary measure. Temporary injunction is granted after hearing the opposite side, and perpetual injunction is granted only after the evidences of the facts and documents are filed on both sides, the arguments are heard, the case law is also cited, and they are appreciated issue by issue. Then the temporary injunction becomes a perpetual injunction. So, interim injunction and temporary injunctions are governed by the Civil Procedure Code, Order 39, Rule 1 and 2. But as far as perpetual injunction is concerned, it is covered by Section 38. Then we go to Section 39, which speaks about mandatory injunction. What do you mean by mandatory injunction? The word mandatory itself comes from the word mandate. Mandate means command. Mandate means order. Mandate means direct or order that a particular thing has to be done at any cost. then it's called a mandatory injunction. For example, let us say the GHMC or the municipal corporation is failing in its duty to remove the encroachment, remove the trespass by the opposite side, or let us say the other side has closed the road with a compound wall and prevented you from ingress and egress, and not only you, but the other people also, then in that case, you can make a complaint to the GHMC to remove the encroachment. But if the GH naturally, GHMC is not going to act immediately. But where you compel another side to do a duty which they are bound to do under the law, which they fail to do, and acts of omission on the part of the authority to perform its statutory duties, you can compel them to perform it by filing a suit for mandatory injunction. Or I put it this way, sir. When you file a suit for perpetual injunction not to construct on your particular land or encroach on your particular land, even if you obtain a temporary injunction or interim injunction, let the other side completes the construction or encroaches on your property. But what to do? You cannot keep quiet by only taking a decree for perpetual injunction. What you have to do is you must file a suit for mandatory injunction or amend your claim and ask for the additional relief of mandatory injunction to direct the other side to do what they have not done, then remove the structures departmentally or at his cost, and then a decree for mandatory injunction can be passed. So, in other words, mandatory injunction is nothing but a direction given or a command given or an order given where you try to correct a person who has not done his duty and compel him to do the duty which you should have done. That is, in other words, I put it in short, perpetual injunction promotes inactivity, not to do a wrongful act. But as far as mandatory injunction is concerned, it promotes what is called activity. What you are omitted to do, what you are supposed to do, what is your statutory duty, why you are prevented from doing it, why you have not done it. Then an order is passed by the court. Please do it. At least you have not done it till now. Do it now. If not, the arms of law is very, very long. We know how to compel performance. These are the three basic injunctions which are given at different stages. First is again repeating it, ad interim injunction is given at the stage of filing unless special grounds are made. It is given for a specific duration of time and it is not permanent and it is extended from time to time unless the counter is filed by the other side. And then once the arguments are heard on the injunction application on both sides and the facts are mentioned, the documents are filed, then the court hears the arguments and then the interim injunction gets converted into temporary injunction. It continues till the disposal of the suit. Then suppose that is in other words, it promotes what is called inactivity. That is already the act is in the process of being committed. They say put a full stop to that, don't do it anymore. But mandatory injunction is when the duties are not performed and there's a clear violation of the laws or clear violation of the orders of the court, a mandatory injunction can be granted whereby the other side will be compelled to do its duty which it has omitted to do. Then in Telangana, we don't have so much of water resources. A particular field only has got what is called a well from which supplies water through the motor to all these neighboring fields. Let us say this has been used for a long period of time, for 20 years, let us say. Not only you, but people from the village are using it. Then abruptly, you cannot construct a compound wall or a fencing and stop the usage of water from that particular. Then in that case, you can file a suit for mandatory injunction to direct the other side to supply water which he was doing either to. Then Telangana is full of what is called ethnic festivals. For example, next month we are having the Ashada Masam, where the Bonalu comes to Telangana, and Bonalu is celebrated with gay and gaiety. And suppose let us say nowadays Durga has got nine avatars, Nalla Pochama, Maisama, Ellama, so on and so forth. Suppose temple is in your field and people have been worshipping there for the past 20 years and they offer bonum at that place or offer rice, so on and so forth, you cannot prevent them from doing it. Suppose you close that passage and don't allow them to go from that passage, and a mandatory injunction can be granted, preventing you from committing that mistake. And even if you put obstacles, you will be directed to remove those obstacles and provide for performs of the rituals as in festival days. Or you got the Batkama festival. Batkama festival also sometimes the river water is used where you leave the flowers. So suppose let us say the tank bed is closed, you cannot immerse your what do you call your flowers and all as per the rituals. Then a mandatory injunction can be granted, directing the other side to permit the immersion of what is called the flowers uh, in water. Then you got in Hyderabad, the nowadays you got unfortunately what is happening is every festival is being made a big show today, especially the Ganesh Chaudhary which comes. And the Ganesh Chaudhary time, 10 days celebrations take place, and after the 11th day, the idol is immersed in Tangman or some river waters, whereby they say God has come from down. God also will go back to the same place. But suppose the government prevents your immersion of the idols in the Tangman or any other riverbeds, a mandatory injunction can be granted whereby to stop whereby to direct the authorities to allow the immersion of the idols in Tangman or the riverbeds. But please remember nowadays slowly the government is coming around whereby they have constructed small tanks. They say people from a particular locality, whenever they have to immerse the idols, they must immerse it at the pond which is maintained for that particular purpose of immersion alone. Then you got one more festival called Kali Mata, that is Dasara time. During Dasara also the Kali Mata is also immersed in water and the immersion takes place in river waters, a lake or whatever it is. These are all rituals which are coming from times immemorial. If they are discontinued, the courts will interfere by issuing mandatory injunction by promoting activity and not inactivity as in for ritual injunctions. So this is as far as I've dealt with it in detail when I was dealing with the law of injunctions in the Civil Procedure Code. And please bear one thing in mind that interim injunctions are granted under the provisions of CPC. Temporary injunction is granted under the provisions of CPC. Perpetual injunction is granted under the principles governing injunctions in section 38. But ultimately granted under the Civil Procedure Code, but as far as mandatory injunction is concerned, it is not covered by CPC, but it's governed by specific relief act. To be more precise, it is Section 39. Then we go to what are the reliefs that cannot be granted under the Specific Relief Act. That is the last section of the Specific Relief Act, which says to restrain a person from pursuing his legal remedies. That means you cannot take an injunction to prevent a person from filing a suit against him when he has got a money claim against you or any right against you. You cannot take an injunction stopping him. Suppose you are indebted to him, you can definitely file a suit for enforcement of his money or to recover his money. You cannot prevent him from doing it because that's the first bar under Section 41. The second bar, which is where injunction is normally not granted, is where you prevent a person from pursuing his criminal remedies under the penal code. That is, to initiate criminal proceedings in case of any criminal offense that has been committed, you cannot take an injunction against that person to prevent him from approaching the police. The third instance where injunction is refused is you cannot get an injunction issued against a court to proceed or to what is called not to proceed against a particular matter. Anyone can approach the court at any time. Court is not bound by injunction. Only the Supreme Court, the higher court can issue stay orders, but they cannot prevent the lower court from performing its duties. An injunction cannot be issued to restrain a court from proceeding with the matter. And fourth one is no injunction can be granted preventing a person from offering himself for election in to elected offices like corporations, then ZTPC, MTPC, then legislatures, legislative council, or the parliament as the case be the upper house or the lower house. Every man has got a fundamental right to contest for elections and offer himself as a candidate, provided he satisfies the requirements of the Representation of People's Act. These are the instances where injunction cannot be granted. And another thing, when you have got a right, a particular personal right against the opposite side, you cannot delegate those rights to a second person to say that please fight my case, fight for my rights, and get your cause espoused, take an injunction. Whatever rights are available to you as a person, you alone should approach the court. You cannot delegate it to another person. These are the various instances where injunctions are not granted under the provisions of Section 41. Then we go to the biggest chapter in the specific relief act called Specific Performance of Contract. Specific performance of contract is laid down in Section 10 to Section 24 of the Specific Relief Act. Specific performance is incorporated in Section 10 to Section 24 Specific Relief Act. That is, the positive enforcement of a contract is what is called specific performance. That is, specifically performing the terms of the contract entered into between two contracting parties is what is called specific performance. In the letter as well as the spirit, it is called specific performance. I have been repeating it throughout that this is a remedy called out by the equity courts. I think we'll have a break for 2 minutes, please. Just excuse me for 2 minutes. As far as specific performance is concerned, I'll come to the history how this doctrine was evolved. Earlier, in the Westminster Palace, common law courts existed. And in England, a common law court could come into existence only by a charter issued by Her Majesty, the Queen of England. And charter was issued, and three separate courts were constituted for different functions. One was called the Court of Exchequer. Court of Exchequer means all financial matters used to be dealt with by these courts. Second one is Court of Common Pleas. What do you mean by Court of Common Pleas? Court of Common Pleas mean that like money suit, then other reliefs which are normally available under the common law is called Court of Common Pleas or damages, etc., etc. But as for the next court which was existing was called the Queen's Bench, which was presided over by judge under the delegation provided to him by the Queen of England. Then slowly what happened was whenever a contract was violated, whenever a breach takes place, or whenever the party complains to the court, sir, we have entered into a contract and all the valid ingredients of contract are present, the other side has committed a breach. Please compel the other side to perform his part of the contract. I am ready and willing to do my part of the contract. I have already performed my obligations. The other person has not performed his obligations. Please compel him to perform his part of the contract. But the common law courts simply said, under the law, under the powers that are given to us by the charter issued by the Queen of England, it was said that a breach of contract or a violation of the contract was only a civil wrong and only a claim for damages would lie. They used to wipe the tears of the wronged party by awarding money compensation and some extra money by way of damages. Please remember in law, we have got a maxim called justice should not only be done, but also deemed to be done. Has a person come for fun's sake to the court, sir? Has he come only to take money and get back? No. He wants to see that the contract is performed in the letter as well as in the spirit. And he also wanted to know that there should be a methodology through which both the parties should be sincere, both the parties should perform their respective obligations. There shall not be any breach of contract on either side, and When the contract is there, it should be honored in all respects. But what the common law court said was, as far as performing the positive aspect, that is for enforcing a contract, it is we have no power at all. Then what happened was, those days they used to say, even today they say, long live the king or long live the queen. Queen or the king is the fountainhead of justice, and they say king can do no wrong. Though the king or the queen is only a figurehead today, but still they have got enormous powers. Here, what happened was slowly pensions started pouring in to the queen for redress, and at one time, in the 16th or 15th century, UK was ruling almost two-thirds of the world, and the sovereignty of the crown of England extended almost to two-thirds of the world, and two-thirds of the world were all colonies. And even India was a colony of East India Company, which subsequently the British government was ruling us till 1947. Then what happened was that the queen was flooded with a lot of petitions to dispense justice. Then those days the queen had no time to attend to judicial functions, and she was always overworked. So what she did was she delegated her functions to her conscience keeper, that is the Lord Chancellor. Lord Chancellor is today named in England as the Prime Minister. We don't have Lord Chancellor now in India. I'm sorry, in UK. So the Lord Chancellor was the conscience keeper of the Queen, and he was the holder of the King's authority and the seal of the Queen. Then what happened was separate courts were constituted called equity courts. And one side of the Westminster Palace, there existed the common law courts, and the other side of the Westminster Palace existed the equity courts. That's how the equity courts came into existence. And equity courts evolved the doctrines to say one who comes to equity must come with clean hands, and one who seeks equity must do equity. That means whenever there's a contract, all the valid essentials of contract are satisfied. There is offer, acceptance, capacity, consideration, consent, and legality of object. Law should not be helpless to come to the rescue of a person whose rights have been violated. So slowly what they did was they evolved the doctrine of specific performance. That's how specific performance came into existence. They also evolved the doctrine of what is called injunctions today, what you have. That is preventive relief or prohibitive relief, where they said the negative aspect also. They said, as far as the negative aspect is concerned, we can also prevent a person from committing a breach of contract whenever trust and confidence is reposed in one person, and the person who reposes confidence changes his position, which should not have done, but for the trust and confidence reposed in the other person, then the other person, however difficult it may be, must honor the contract in toto. That means he is prevented from acting contrary to the terms of the contract. That's how injunctions were created. Then I also discussed, I think yesterday I discussed that case of Lumley versus Wagner. This Lumley versus Wagner came up before the equity courts for redress. In that particular case, the Wagner was a reputed opera singer like Lata Mangeshkar of our Hindi screen, whereby she entered into a contract with Lumley to perform in the opera theatre of Lumley for 3 continuous weeks, and during the contracted period, she agreed that she will not perform in any other theatre. Then she committed a breach of contract. She had greener pastures. She committed a breach of contract whereby she stopped performing in the opera theatre of Lumley. And she wanted to enter into a contract with a third party to perform at their theatre. Then Lumley brought an action against Wagner for specific performance for positive aspect to implement the contract, and second one is to prevent her from performing in any other theatre. In this case, in the earlier days, the equity court said they can only enforce the negative aspect. What is the negative aspect, sir? Not to perform during the 3 weeks period, that is a contracted period, but as far as the positive aspect is concerned, to perform at the opera theatre of Lumley, they cannot enforce it. And of course, a lot of changes have taken place later on. I think perhaps cricket is a religion as far as our country is concerned. And please remember, the BCCI, which is the controlling body, issues contracts to various cricketers, and they are bracketed as A grade, B grade, and C grade. They are paid monies per annum, and they are also paid the match fees as well as the performance fees and incentive fees also. And on the terms of the contract, a cricketer under the contract with the BCCI undertakes that he shall not participate in any of the cricket leagues which are held by the various countries on a lucrative basis without the permission of the board. And in case he wants to participate there, no objection certificate has to be obtained by the BCCI. And if he does not do so, he has chances of his contract being cancelled and he may be made liable as far as damages are concerned. So that is the reason nowadays, T20 league has become very, very popular. Slowly, what is happening is a day has come when the 5 day cricket and the traditional form of cricket may vanish from the cricket scene. So, because in T20, it is rags to riches. Most of the people who have been living in slums today have become rich. I think you take the example of two cricketers, sir. Mohammad Siraj of Hyderabad, whose father was only running an auto rickshaw, is today a millionaire because of the lucrative IPL contract and the contract which the BCCI has given to him. Then take the latest example of Yashasvi Jaiswal, who was having a panpuri shop outside the stadium, and then slowly he came to limelight, and today he is also a courier because of the contract with the BCCI. What I'm trying to tell you is, but please remember, most of the people today, senior cricketers, professional cricketers, are foregoing the Test cricket, and most of them are driven towards what is called T20 cricket, where you have more money. Wherever vitamin M is there, they come to that particular place. So, in order to see that a set of contracted players are available, the board enters into a contract with them, pays them the money per annum, or also pays them the match fees, and also sees that they should be available to play for the country at the time of test matches or ODIs or T20s. But it is quite a contrary thing now today. Most of the cricketers who retire from their professional circuit, they are joining the T20 league, but please remember they are not under contract with the BCCI because the question is they are free to do anything. Then in that case they play in various leagues. Today you've seen the team like USA is coming up as far as cricket is concerned, where only rugby used to be played and American football used to be there. Today cricket is becoming a popular game in most of the European countries also. Also, what I'm trying to drive at is in that particular case they said they cannot prevent Wagner from they cannot compel Wagner for performing in the Opera Theatre of Lumley, but that they can definitely stop her from performing in any other opera theatre during the period of the contract. That was what they said. They enforced a negative agreement, but the positive agreement was not enforced. But this as far as there was a conflict between the common law courts and the equity courts, and that resulted in the famous case of Chief Justice Coke versus Addington. Chief Justice Coke was the chairman of the common law courts, and Addington was the person who was presiding over the equity courts. The question arose there was who is superior, the common law courts or the equity courts? And the matter was referred to the Queen for redress. Then the Queen discussed it threadbare and said, Sir, equity courts have not come in to destroy the law. Wherever there's a deficiency in the common law, it has come as a vitamin to plug those loopholes and to provide adequate relief to the parties. So each one has got its own sphere of activity. No one is superior and no one is inferior. They held it in the court. Queen held it in favor of the equity courts. That's how the equity jurisdiction started developing. So, but the question arose whether equity law exists in India. Please bear one thing in mind. In India, we do not have a separate law of equity, or we do not recognize what is called equitable estates, but definitely every principle of equity is incorporated or included in every law. And one of the laws where equity doctrines were evolved was the Specific Relief Act, Section 10 to 24. Today, all of you can boldly say, sir, whenever there's an agreement and all the valid essentials have been complied with. There is a methodology through which you can file a suit for enforcement of the contract by filing a suit for specific performance. And you can also prevent the other side from committing a breach by taking an injunction to restrain them from doing that wrongful act. All these things are created by the law of equity. Though we don't have the law of equity in India, but still equitable principles are permitted itself the various spheres of activity. And one of the spheres of activity where they are permitted itself is the doctrine of specific performance. Exactly what is the meaning of specific performance under section 10? Specific performance is performance of the obligations laid down in the contract, performance of the respective obligations laid down in the contract, both in the letter as well as the spirit, without any violation or without any breach, is what is called specific performance. In other words, the positive aspect of a contract, that is enforcement of the contract, performance of a contract, obedience of a contract, or implementation of the contract, is provided by specific performance. So gone are those days when you could just make an agreement just for fun's sake and then just pay the money, whatever is the money you have received, and then plus some 1 or 2 lakhs as a peanuts, and then get away from the contract. So you could avoid a contract under the common law. Today, you've got a methodology through which you can get your agreement specifically enforced either in the letter as well as in the spirit, and no person, be it the vendor or be it the vendee, can avoid the contract from being performed. And one of the defenses taken by most of the sellers today is, sir, at the time when the contract was made, sir, it was 75 lakhs. Today the property values have escalated. Now it has become 2 crores. As far as the property is concerned, I don't want to sell the property for 75 lakhs and suffer a loss. I'm prepared to sell it for a higher price because of the escalation of prices, and I'm prepared to return back the money which I've taken as advance and some money towards damages to the opposite side. Please permit me to avoid the contract. Please remember, however difficult it may be, however irksome it may be, however hard it may be as far as you are concerned, however, whatever hardship may be caused you because of escalation of prices, all these things are not a criteria to avoid the contract. You must perform the contract both in the letter as well as the spirit. That's what section 10 says. I think with this we shall stop, and we shall continue the rest of it. The next class, that is tomorrow, because I want to go as slow as possible because it reaches a person of minimum IQ also, because I can go on a high flow, but how far it reaches a person who is short of understanding or who knows it, but sometimes there's a difficulty in understanding it. I will go as slow as possible, please, because this is a subject which you have to know thoroughly. Because the entire suits which are being filed today, I think most of you know also, in places where property prices have increased and a contract is made, specific relief act plays a very important part. Now I call upon you to interact and ask questions as to the topics which we have discussed. So please remember, wherever I start, I also try to repeat the older topics of the previous day so that it's a sort of a recapitulation and most of you remember it. If you have got any doubts, please try to ask. And now the interaction period starts.
Sir, good evening, sir.
Good
This
evening.
is Avinash Karapati, advocate, sir.
Yes, sir.
Sir, as 39 Rule 1 and
Two.
the amendment, Order 39 Rule 1 and 2 of CPC,
Yes.
the amendment was High Court of Andhra Pradesh, the composite Andhra Pradesh, 26/7/1956, that is 26 July 1956. There was an amendment in Rule 1,
Yes.
and the amendment was that there were R was added, the word R was added in every subclass of Rule 1,
Yes.
A, B, and T.
Yes.
That the understanding of R is discretion of the court to select the reliefs sought for by the plaintiff or by the counsel. But it has been again it has been governed by Rule 55 of CPC, that only one relief in one interim application should be sought for. That is, two reliefs in one interim application cannot be sought for.
Right.
That is been covered by the CRP 55, Rule 55 of CRP.
Yes.
Sir, then at a time, how many reliefs can be sought for in different now the Rule 55 is been implemented or attracted. Then in one IA we cannot seek two reliefs.
Yes.
So we have to file following IAs for different reliefs.
Exactly.
So it is discretion of the court to provide relief to the plaintiff.
Right.
Or the petitioner in the petitioner plaintiff.
Right.
Then at a time, how many reliefs can a court give?
Sir, I'll put it this way, sir. Actually, it's a cardinal principle that two reliefs cannot be claimed in one petition. How to get over it is file multiple petitions. No one stops you from filing multiple petitions and ask for separate reliefs in each petition. But one thing is this: two reliefs cannot be asked except in execution. When you file a petition under Order 21, Rule 21, asking for simultaneous execution. But as far as your CRP which you are quoting, it's a known position of law that two prayers cannot be there in a single petition. But if you see the way we draft the affidavit, if you see, we say that I therefore pray that that the respondent be directed through an injunction not to alienate the suit scheduled property pending disposal of the suit. But there you cannot say, but you use the word composite words: alienate, encumber, charge, or create any other obstacles as far as the property is concerned. And I'll also tell you the methodology through which you can avoid court fees. Here, the methodology is when you file IAs, only you get away with ₹2 stamp which you are fixed. But if you ask for a distinct relief, then you will have to value that separately. Then one thing is this, and that's why there is one section 6 of the Court Fees Act which says multifarious suits can be filed. Suppose you pay the court fee on the higher relief, specific performance, let us say, consequently you can ask for injunction. You need not pay separate court fee because section 6 provides for that contingency. But as far as your question is concerned, whether two reliefs can be claimed, please bear it in mind, except in a suit where you file the plaint, multiple reliefs can be claimed. But as far as an interlocutory application is concerned, only one prayer can be made, sir.
Yes, sir.
Am I making myself clear too, sir?
Clear, sir. Clear.
Thank you. Next.
7, that is 7th class. 7th? Malamni, 7th class start. Already Varam class. He is taking classes till August end. Every day, 1 hour lab. Man Malamni, Maza login with Bulgim. Apal Saranga Kaiko de he is online. He is asking for questions. Anybody?
We are in the interaction, please. Next.
If you have any questions, you can ask. This may already
Yes. Yes. Can you say that there are no more questions? Mr. Vasantarao. Yes.
I have no questions, sir.
Thank you. I think we wind up. Sam and other children.
Good evening. This is Anuradha.
Yes, madam. Anuradha Bakaraja.
Yes, sir.
Yes.
Sir, this is with regard to mandatory injunction, which you have just discussed.
Yes.
You this as per section 39 of CPC.
Not CPC, madam. It's specific relief.
Okay. Then fine, sir. My doubt is
Thank you.
you. Thank you.
Any more questions, please?
Thank you. We wind up as of now. Any doubts? We'll see you tomorrow again. Thank you very much.
Thank you.